So I believe that the Fifth Amendment actually says what it means and means what it says. We Americans get a grand jury right. We Americans get a grand jury right because it's in the Fifth Amendment. But you goddamn Hurtado and Crookshank sons of bitches. You Hurtado lovers, you Crookshank lovers, oh, you just love Morrison Waite, don't you? You just love Morrison Remick Waite. You say I'm wrong, but you sons of bitches are living in the past. First things first. A major reason for a grand jury immunity is to judicially determine probable cause. Before you go to a jury trial, that's Gerstein v. Pugh, 1975. It declares that a judicial determination of probable cause is an absolute must. The grand jury immunity from a trial jury will be irretrievably lost if allowed to go to trial without it. That's Midland Asphalt versus U.S. 1989. Midland Asphalt. The Midland Asphalt decision is Scalia. That's fucking Scalia. This is a conservative court. They hold Scalia up as a god. Originalism upholds the grand jury right. Just go back in time. 11 states of the 14 constitutional conventions ratified the Bill of Rights in 1791. That means out of the 14 constitutional conventions, they read the Fifth Amendment. They read the Fifth Amendment and they agreed with it. 11 out of 14 constitutional conventions ratified the Fifth Amendment. In 1791, that's when the Bill of Rights was passed. In 1791, 4 states of the 14 protected the grand jury right outright. 3 by constitution, 1 by statute. Maryland's 1776 Constitution, North Carolina's 1776 Constitution, Pennsylvania's 1790 Constitution, and New York's 1787 Bill of Rights. In 1791, 13 of the 14 states had constitutional or statutory protections for the common law. So, if they didn't outright protect the grand jury, they protected the common law, which is the grand jury back to 1166. The grand jury has been law in English American jurisprudence for 800 fucking years. It's estimated that 27 to 33 of the 37 states in 1871 contained the grand jury right in their constitutions. Harlan's dissent in Hurtado at 557 wrote that it is a fact of momentous interest in this discussion when the 14th Amendment was submitted and adopted the Bill of Rights and the constitutions of 27 states expressly forbade criminal prosecutions by information for capital cases, while in the remaining 10 states they were impliedly forbidden by a general clause declaring that no person should be deprived of life otherwise than by the judgment of his peers or the law of the land or without due process of law. Point number 3, I got 38 reasons. I got 38 reasons of why the grand jury right is American law. It was American law back in 1800s, 1791, 1900s. It's American law today. It was American law yesterday, today, tomorrow. It's going to be American law forever. 88 to 95% of the Bill of Rights have already been incorporated, certified, and sanctioned by SCOTUS. 88 to 95% of the Bill of Rights have already been incorporated, certified, and sanctified by SCOTUS. So most of the Bill of Rights are already goddamn applied to the states to begin with. You only have, what, the Third Amendment, the Seventh Amendment, and the Grand Jury Clause? And technically, do you need the Supreme Court to tell you that one of the freedoms in the Bill of Rights is your freedom? Frankly, we need to have capital punishments, and then we need to have capital freedoms. We need to have a list of 10. Let's go ahead and just put the 10 Commandments into practice, and let's put the Bill of Rights into practice. Those are the 10 cardinal sins you cannot do, and those are the 10 freedoms that you cannot infringe upon. If we don't believe in the Bill of Rights as of today, I mean, we fought a revolution for the Bill of Rights. We fought the Civil War for the Bill of Rights. How many more revolutions do we need to fight in order to have the freedoms listed in the Bill of Rights? And a right is a freedom, is a liberty, is a privilege, is an immunity. They're synonyms. A right is a freedom. A freedom is a liberty. A liberty is a privilege. And a privilege is immunity. You have a right to speak, so you could write, fuck the Supreme Court. And by the virtue, by your privilege as an American citizen, you are immune from prosecution. Today's Supreme Court is made up of strict constructionist, originalist, textualist, which means that they apply the plain meaning of the text of the Constitution, which includes the Fifth Amendment. Number 6, during oral arguments for Timms and Ramos, when confronted with re-adjudicating the 18th century Bill of Rights in the 21st century, Justice Gorsuch asked incredulously, really? Really? The Fifth Amendment, American grand jury right, has the same level of authority as our Second and Eighth Amendments. The problem with resting upon precedent is that when it's decided wrong, then it keeps on being wrong. All of the procedural rights from Amendment 1 through 8 have been incorporated except for one sole outlier, the grand jury right. Incorporating the Bill of Rights would make our principles uniform across the nation and the world. The relationship between the Bill of Rights guarantees and the states must be governed by a single neutral principle. That comes from McDonald. No grand jury indictment, presentment, or hearing, nor an equivalent preliminary evidentiary probable cause hearing is a violation of due process. A cop kidnaps somebody. Is that it? The wham bam, thank you ma'am. A cop kidnaps somebody, so fuck you and fuck your goddamn, for a goddamn insecure judge, they like to judge the bodies that they collect. But does that get us to justice? One of the end objects of the preamble is to establish justice. Number 8, no grand jury indictment, presentment, hearing, nor an equivalent preliminary evidentiary probable cause hearing is a violation of due process. Alito references Hurtado in Ramos, where he says that preliminary hearings may be substituted for the lack of a grand jury presentment and or indictment. So for you Hurtado-loving sons of bitches, if you say, no, you don't have the grand jury right, okay, well, you got to have some sort of preliminary evidentiary probable cause hearing. That's fucking Hurtado. You Hurtado-loving sons of bitches don't even understand what Hurtado is. You fucking backwards-ass piles of shit. The federal government has used and continues to use without blip and will most likely for as long as the compound Republic of America carries on, use the grand jury in felony, infamous, and capital cases going forward. Since 1791, without question, without any lapses, the grand jury right is America's past, present, and future. In federal court, you can't have a felony charge without a grand jury indictment. So how come the fucking states can goddamn get away with that shit? It's fucking bullshit. We don't have the fucking 10 commandments. The 10 amendments aren't 10 commandments for our freedoms. Number 10. Today, 48 states of 50 have grand jury provisions. Over 20 states use mandatory grand juries for felony prosecutions. So out of the 50 states today, 48 states have grand jury protections. And then over 20 states use mandatory grand juries for felony prosecutions. So it's not going to upend the entire country. Over 20 states already use the grand jury properly, correctly. It's the other fucking dumbass, fucking backwards ass states that haven't been protecting our rights and freedoms as specifically dictated, enumerated, written out in the sacred and indelible U.S. Constitution. The constitutional rights are self-executing. Sally American gets to understand her Constitution. So Sally American sat inside her house, read the Constitution, says, hey, I have a right to speak, a right to petition, a right to peacefully assemble. She doesn't need a goddamn judicial determination to tell her that she gets those freedoms. It's in the Constitution. It's right there in black and white. It's hypocritical for SCOTUS to create dozens and dozens of freedoms out of thin air, like a right to marriage, Loving v. Virginia, Turner v. Safley, Obergefell, or a right to have children